here tonight, and tonight we'll be discussing the estate planning, estate administration, and the focus on the wills, probate, alternatives, and recent changes in the law. Our presenter tonight is Mr. Manners, Chris Manners, with the deputy officer with a register of wills. And he said the best way for this program to be effective for everybody is your questions afterwards. So they'll give a presentation.
What's your name?
Bob Wilson. But anyway, like I said, he said the best way this program works is after he gives his presentation, your questions make it more effective. So I'll be here and I'll pass around the mic when you when we get to that point in the program. Spanish.
Thank you very much. Again, my name is Chris Manners. I'm the Chief Deputy with the Register of Wills for Frederick County, Maryland. Mary apologizes for her inability to be here this evening. She is right now meeting with our legislators to talk about it. So she hopes you will forgive her, and hopefully I'll serve as a decent stand-in. A little bit about myself. I'm an attorney by trade, but the nice kind. The admission to the bar was in 2003. My first stint was as an estates and trusts lawyer with a boutique firm. After that, in about 2010, I jumped ship over into public service, and I've been with Register of Wills since then. And what we do is twofold. We actually go ahead and administer estates for decedents in Frederick County, and we also serve as a tax collector for the state of Maryland, because there is inheritance tax still in Maryland. To let you know a little about our office, we have 11 people. About a third of those are estate administrators who are responsible for opening up new estates, new proceedings. There are several auditors, and then we have supervisory personnel to fill in all the blanks. What I basically do is backstop for everything. So I've got a pretty good idea about how the law works, how it dovetails with what people do, and what your general results might be if you take a particular course. The nice part about probate in Maryland is it's relatively simple, relatively affordable, and you will occasionally hear people put out sales pitches for a variety of different alternatives to probate. And we can talk about some of those, and we can talk about trusts. We can talk about anything you'd like to talk about this evening. But I'm going to give you a brief overview of what an estate administration would look like, and we can move forward from there. So when a person dies, they're either going to be intestate, having passed without a will, or testate, having a will. And the will actually is the foundation of every estate. When a will is presented to the Register of Wills with proof of death, and bear in mind this is a legal proceeding, so we do need to actually be certain that the person has passed away. When that happens, the register has the ability to administratively probate that will. What that basically means is that people no longer have to wait for the court to come into session so that they can judicially admit the will. And we handle probably 99.5% via administration. And when a will comes into our possession, it never leaves. We hold it through the duration of the administration. And then after we're done with the administration, we eventually move that over to archives. So at some point in the game, if you pass away in Frederick County, you'll eventually be famous. Not much of a benefit there, but we take what we can get. In the administration part of things, we also are responsible for safekeeping of wills. And what that means is if you draft a will and have it presented to us for safekeeping for a $5 one-time fee, we can actually put that into our vault and keep it there until somebody presents proof of death, or you personally request that it be drawn back out. So it's a nice service. It's handy. We have about 45,000 wills right now, and the number keeps expanding the same way Frederick County does. So it's going to be interesting to see how full our vault can get. After the will is brought into our office, a person has to be appointed as executive. In Maryland, we call that a personal representative. And that personal representative is responsible for marshaling, collecting all the assets of the estate, making sure that claims are handled, that all just debts of the decedent are processed. And if there's remaining funds left over after that for distribution to the persons who would be picked out in the will or governed by intestacy. And at the close of all that, they have the ability to go ahead and request termination of the appointment or continuation. And if nothing happens, it'll just keep floating on forever. Excuse me. The administrative part of it itself, there are several components, and most administration in Maryland, I'm going to say probably 2/3 of estates are what are called small estates. And those are of $50,000 of magnitude or less, or $100,000 if there's a sole surviving spouse who's taken. Anything in excess of those figures is called a regular estate. But small estates make up the vast majority of what we do for a couple different reasons. One, people sometimes don't have that much in terms of an estate to leave behind. Two, they utilize probate avoidance mechanisms, we can call them. Sometimes they're trusts, sometimes they're joint accounts, sometimes the property itself is beneficiary driven. So there's really nothing for us to do about it. In terms of property that goes into an estate, the only thing that can be probated are assets solely titled to the decedent. Can't be joint, can't be beneficiary designated. And as a direct result, most estates are smaller than the total gross estate for tax purposes. So when we open up a small estate, normally what happens is a one-day process. And all the documentation is drafted by our office. We're there to help. And when the documentation is signed off on, what we do is direct the personal representative in how to go ahead and make distribution, how to pay debts, how to do the things that are necessary to do. And that's the end of the story. That's probate for small estates. When you get into regular estate territory, it gets a little bit more complicated. On day one, we go by appointment date. When a personal representative is appointed, that starts the clock. And there are a series of documents that actually fall due within timeframes after that appointment. 90 days after an information report falls due, that's a document that essentially asks, did any material part of the decedent's estate go to somebody who was subject to inheritance tax? And that's a big statement in itself. We'll circle back to that. Did the decedent own any property out of state? Did the decedent have a trust? Did the decedent have anything that they needed to go ahead and deal with in a, there's no easy way to explain this. Sometimes there are interests that will vest in one person than another. Those are generally called life estate interests. And again, we can circle back to that. So the information report falls due 90 days post-appointment. The inventory falls due at the same time. And what the inventory does is it chronicles what the decedent owned in their sole name as of date of death. So the value is fixed at a point in time. There's a creditor's claims period that runs in every single estate in Maryland, and it lasts for 6 months, where a creditor can come forward and present a claim against the estate that should be addressed before closure of the estate. At the 9-month period, a first administration account falls due. What that does is it tracks changes in assets, sales, distributions, anything that happened, expenses, fill in the blanks during the period from the date of appointment to the date of the account. And after the first account, if more are necessary, then they fall every 6 months thereafter until somebody says, I've had enough. And they can file what's called a final account, and that signals to the court that they're ready to get out. Now, we work in conjunction with the Orphans Court. They are not really related, the register and the court, but they are allied organizations that work closely together to make sure that everything that's supposed to happen does. And again, these are legal proceedings. So how do you get from here to there? Well, most of you have some form of estate planning in place already, whether it's formal or informal. It doesn't really matter. What a lot of people do is they'll tack kids onto accounts. And there are pros and cons to that. People will set up life estates in real property and keep themselves as a life tenant on the property with a remainder to children. Sometimes people will set up TOD or POD, transfer on death or payable on death accounts that they can utilize for the entirety of their lives. And then at the close, the asset transfers over to beneficiaries. So there's a wide array of different things that you can do without any kind of formal drafting. But apart from that, you're down to wills and trusts. Now, wills are only valid when the person passes away. So if I execute a will today and draft out all the terms, I have all the time in the world to change that any way I want to up till the day I die. And when I die, it's fixed. The will speaks at death. So that is nice and final. But trusts are an alternative to that. And how they function is kind of like an LLC, in as much as it'll hold whatever you put into it, but no more than you put into it. So if you have real property, you have to deed the property over to the trust. If you have accounts, they have to be set up payable to the trustee of the trust. There are some benefits to having a trust. One of them is privacy. Probate is a very public process. Not that anybody really cares about it. We don't have nosy neighbors coming in every other day, which some people might believe. But it is public, and the documents that we produce and everything that transpires happens in the public sphere. Trusts don't. Trusts are private. Trusts generally operate by power of, they don't terminate. So by operation of law, when a decedent passes and they leave instructions for who's the next trustee and what should happen to the assets in the trust, it just keeps on going like an LLC. Privacy is the most important part, really, of trusts now. It used to be that people would set up a trust because Maryland, 15 years ago, maybe 17, it's getting such a long time ago. Oh my gosh. Maryland used to have a threshold for the estate tax, which is a tax on what you own. And that the threshold was $2 million. And to maximize that, what people would do is develop a trust that split into an AB, like a family trust and a marital bypass. And what that did was effectively doubled the amount that you could put into the trust and keep it free from taxation. So there used to be a lot more need for that, because I don't know who does it, but it sure isn't me. Apparently $2 million is not that hard to come up with anymore. No. Now the federal exclusion amount is somewhere in the neighborhood of about $11 million for some ridiculous sum. I mean, if people see that, God love them, but it's nobody I know. And as a direct result, the privacy feature of trusts has become much, much more important than the tax avoidance benefits of having a trust. So really, when you look at it, there are a lot more upfront expenses with the trust, not so much with a will, but the administration is still going to be required at the backside of either one. So you have to get the assets from one generation to the next And the easiest way to do that I've found is by probate. I'm going to go ahead and kind of open this up a little bit. So when you have questions about what I'm talking about, feel free to raise a hand, fire off a question, do whatever. I think this is much more beneficial when we talk to each other rather than I spout information.
You're just now talking about the tax benefits that used to be in place for a trust. Now, since the state tax is so much higher, from my observation, it seems like trusts, because trusts do have to pay taxes every year. If someone didn't have, right, I think.
Most trusts are grantor trusts, and what they do is actually they're taxable to the individual.
To the individual who's given the money.
Exactly, the grantor.
But if you didn't have that, if you just did regular probate and you were a descendant of the person, then you, under what I understand from your publication, you wouldn't be paying taxes on that.
Well, yes and no. There are two different types of taxes that we're going to be talking about. One is the state taxes, and those are basically for your property to be transmitted someplace else. If you exceed a certain threshold, you're going to be taxed. Inheritance tax isn't about what you own, it's about who you give it to. Inheritance tax is based on a Maryland decedent transferring property to somebody who is not exempt from inheritance tax, which is aunts, uncles, friends, cousins, everybody except for immediate nuclear family. And the general rate is at 10%, and it can be accelerated if there's a tax clause in a will, for example, to 11.1%. So between the two types of taxes, the only way you're ever going to run into estate tax in Maryland is if your estate is greater than $5 million. So very few people really have to bump into that. For inheritance tax, anything in excess of $1,000 given to anybody who's not exempt from inheritance tax is taxable. And what a lot of people do is they arrange either in their will or in their trust for the residuary, the remainder of their estate, to go ahead and pay that tax for the individual. And there's case law called Baus v. Hutzler, and what it does is essentially deems that the payment of the tax is a gift in itself, and they stop that after 5 decimal points. So for the 10%, it's 11%, and then 11.1, and 11.1111 is what you end up with. They were kind enough to stop there. But the basis for that is, again, whom you give it to. So if you give it to your cousins, they're taxable, and there's really nothing for it. There has been recent law in Maryland that helps out with domestic partners. And what that law does is essentially, if the domestic partners file an agreement with the Register of Wills office and go ahead and go through that process, then they are freed from the inheritance tax that would otherwise fall due, because there would be no marital relationship, no real relationship between the couple that would exempt anybody. So filing that domestic partnership documentation is basically a way to go ahead and escape the need to pay inheritance tax to somebody that you don't want to marry. Who knew? So I don't know if I got around to answering your question during all that, but there's a lot of information there. But really, for inheritance tax, it really just depends on who you give it to. For estate tax, it depends on how much you have.
But if you were under 5 million and you were trying to give it just to your child.
Normally what happens is people will fill out a pro forma 706. A pro forma basically is kind of like a practice federal return. And at the same time, they'll file an MET, Maryland estate tax return. And what those do is they show the valuation as of date of death of all that property. And the nice part about passing assets to family is that the family get a step up in basis. So What that essentially means is if I buy a house for $100,000 and it's worth $500,000 on the day I pass away, instead of paying $400,000 in capital gains tax, the family gets the full value stepped up of $500,000 in valuation for the home. So there's some benefit there.
But if you did that through a trust, that you wouldn't get that benefit, right?
No, that's not true.
Okay.
Like I said, all these things approximate each other. Probate is just the very public legal way of going ahead and doing it. Trust is a very private quasi-legal way of going ahead and doing the same thing.
Thank you.
Sure.
Just when you said about capital gains, if the house was worth more, I just didn't hear it.
Okay, if I own real property and I bought it for $100,000, when I pass away, if it's worth $500,000 under any other set of circumstances, there would be $400,000 in unrealized capital gains that somebody has to pay the tax for. With a step up in basis, which is what happens when you pass a property through an estate or through a trust, that capital gains issue goes away because you're taking a stepped up basis. So instead of the $100,000 that I bought it for, you receive the property at $500,000, which is fair market value as of date of death. Yes, ma'am.
That stepped up is the same for all of your stocks and everything too.
Not so much in terms of stocks, more toward real property.
Okay, but the
And-
cost basis is
Well, cost basis stays the same for assets outside of real property. There are some runarounds and cutarounds and cutouts for various things, but that's a little further than we need to get in this conversation tonight. But real property is what most people transfer that actually gets that step up in basis and it's treated favorably for tax purposes.
I clarify that example, if the will, it goes from $100,000 to $500,000, we have this, it's just a will.
If it's just a will that gives the property, same thing.
Yes.
Yeah, the step up in basis is completely disconnected from the means of transmission. Now, you can do things like put somebody on as a joint tenant. You won't get the same step up in basis for that. If you have TIC, tenants in common interests, those are discrete. So only the part that the decedent owned would transfer. So you can run into some valuation issues there, but whether it's in a trust, whether it's in a will, no matter how the property is disseminated, the step up in basis issue is related to the fact that you pass away owning a piece of property and there's essentially a forgiveness of that capital gains tax that's accrued over the years. So when my kids take my property from me, they're going to get it with that step up in basis.
Automatic.
Yes, ma'am.
Why did you refer to the trust as quasi-legal?
Well, the reason I say it's quasi-legal is because it's not a legal proceeding from the outset. It's a private document. Now, can it become a legal issue? Absolutely. Just like everything else, we live in the United States. Anybody can sue anybody for anything at any time. Now, whether it stands up in court is a completely different issue, but really to begin with, a trust is simply a document that you keep privately, isn't filed anywhere, and it governs what you wish to happen with the property that's contained inside the trust. Does that help? Okay.
If you donate money to a charitable organization,
Makes me a heck of a guy.
do they have to pay taxes?
No, and most charitable organizations actually fall into 501c3 categories. And as long as they do that, and as long as they're recognized by the IRS, there's really very little that happens in terms of taxation for them. Okay, well, back to where we were. We were talking about ways to go ahead and transmit issue and record moving property from one generation to the next, which is generally what all these things are set up to do. And the legal proceeding that happens with probate is a mechanism by which you can do so. But if you pass with a will, the will actually provides details about who you want to serve as personal representative, how you want the assets to be treated, who you wish to give those assets to, and what you want to do in terms of payment of tax and a few other things. Yes, sir.
You have a will to avoid probate.
No, having a will actually is the mechanism, the key to probate. If you have a will, it basically governs all those things that I said and explains to your personal representative, this is what I want to happen. If you pass intestate without a will, what happens is that there are a whole bunch of rules that fall into place called the laws of intestacy. And those rules are essentially what the legislature decided an average estate should look like and things should happen in that particular way.
Typically, what does it cost for probate?
I'm sorry?
What does it cost? Probate?
Not as much as you might think for. The probate fees range from about $100 to the highest I've seen recently has been 2,500 in terms of the probate fee itself, but that was for a multi-million-dollar estate. So really what the probate fees do is they cover the costs of our office going ahead and doing everything from the inception to the closure. So not expensive, but administration of the assets is a different story. And that is the responsibility of the estate. Sir.
But of course, if in the process you as the personal representative engaged an attorney to do all this for you, then there'd be that additional expense.
And God have mercy on your soul.
And you supposed to will that trust without a lie?
Yeah, well, actually, what people normally do if they go to the trouble of putting together a trust is they have what's called a pour over will. And what that will does is it works in conjunction with the trust to go ahead and scoop up any loose probate assets that might be hanging around and dump it over into the trust. So it's kind of a belt and suspenders approach to the process. Okay. Yes, ma'am.
Okay, I'm really confused, but that's all right.
My job here is done.
Okay. Oh, I'm sorry. Oh, God.
Here we go.
Okay, I have a will
Yes, ma'am.
and I have a daughter who is a lawyer.
Mhm.
And she is the executor
Mhm.
of the estate. Okay, so if I should croak tomorrow, does she come to your office? What does she do first?
The very first thing she should do is call the Register of Wills office to examine whether there is a will.
Okay, I mean, I've got 2 copies, so anyway.
Hey, we're in business now.
Yeah, right.
Okay, the original will is the one that matters. So when you have an original, you either want to file it with the registrar's office or keep it someplace safe where your personal representative knows where to go to get it and has access to it.
Okay, you know, I had it written quite a few years ago.
Mhm.
An attorney in town, would he have? It
is entirely possible that the attorney would have filed it with our office, and all you have to do is give us a call and we'll ask you for the last 4 of your social and we can inform you whether there's a will on file or not.
Okay, that's good. All right, thank you.
Sure.
Thank you.
Those that were executed, I'm sorry, that were created some years
Executed.
ago, in another state, in the state of North Carolina. Do they have effect in the state of Maryland, and how imperative is it that we get those rewritten here? Quickly.
Well, to answer the first question first, a will drafted in any other state that is executed properly in that state is valid in the state of Maryland. So we have full faith and credit in the Constitution, the state Constitution, as well as the federal. And basically what that means is that we credit other states with having done it right. So, is there an immediate need? No. If your situation has changed though, since you executed those, so for example, if people that you wanted to go ahead and pass property to have passed away, or things have happened, or the assets themselves have changed and you want to leave a different structure, absolutely have an attorney go ahead and cast an eye over them, and you can either go ahead and draft a new will or put together a codicil, which is essentially just an amendment to a will.
Oh, you can kind of so on to the out of state.
You can certainly do that. Yes, ma'am.
Is that the same thing with a power of attorney if it's made out of state? Is it good in Maryland?
Powers, not so much. And what you would want to do would be to contact an attorney who does estate planning and have them go ahead and draft up for you all the requisite documentation. There's a series of things like an advanced directive of power of attorney at most, which is life-saving treatment related. And those are very Maryland specific. So it might be a good idea to have that reviewed just for your own safety and ease of mind.
Is there any downside to becoming a personal representative?
Oh, you wouldn't believe.
That's why I'm asking, because I've been asked by people, and I was curious.
It depends on how the family gets along, and that's the long and the short of it.
What's the question?
How well does it serve you to be a personal representative? Is it okay to do? Is it a problem? Are there drawbacks to it? And the drawbacks that we find tend to be that when the last of a generation passes, families kind of dissipate and sometimes don't treat each other very nicely. So as to the whole responsibility part of it, there are no issues. Basically, as long as you're reasonably prudent in what you do, you're pretty good to go.
So there's not a cost to the personal representative of like.
Not personal, no. No, not unless you accept personal responsibility for something. Sorry.
If you have a transfer on death, say, the title of your home, does that just
transfer on death deeds have been trying to get purchased in Maryland, but they really haven't found any traction just yet. Normally what people do in place of that is essentially a life estate deed with or without the power of sale. As to other types of assets, all those would fall outside the purview of the probate process because they're non-probate property. Anything that has beneficiary designations, non-probate.
non-probate?
Yes, sir.
IRA, stocks,
Yes, sir.
and that kind of stuff.
That's correct. See, I told you this worked better if we talked to each other.
Talking about giving money to other, say I have grandchildren and I'd like to give them some money. If it's in like 5 figures, do they have to pay tax on that money? Or can I just, before I die, I mean, like right now, can I just give money?
Yes, you can. No, they won't. And there is an annual exclusion amount from the federal government that approximates about $16,000. So anything above that, they have to file a gift tax return for. So you would definitely be filing a gift tax return, and all that does is reduce your lifetime exclusion amount. It's there's no money that changes hands there.
60,000.
I'm sorry.
60,000.
It's somewhere in that ballpark. I haven't kept up with that. It's a living part of things.
This may not be appropriate, but could you use an LLC instead of a trust?
You can, however, membership interests in trust are regarded as personal property. So what you do at that point is you throw it back into the probate basket. Sounds good on paper until you actually look at it.
I have a question about this gift before you pass away to give to your children or grandchildren. You said 16,000 a year, something like that.
The exclusion amount.
The exclusion amount. And there's a total exclusion amount. And I've looked it up because some years you could give more than that, but if you haven't reached the exclusion amount, you still don't have to pay the gift tax.
Well, gift tax isn't something you pay, it's something you file.
You file.
Yes, and all it does is if you give away $500,000, your lifetime exclusion amount will be reduced by that.
And how do they know how much you've given away? Like if you give them.
Everybody's honest, everybody files their taxes, everybody files gift taxes. I mean,
Like on a birthday, you might give $1,000 here or something there.
anything below that exclusion amount doesn't matter.
Oh. Okay,
Happy days.
yes, happy day.
One thing, add to that, there's that limit of $17,000, so we have to file that gift tax exclusion form.
Gift tax return, yeah,
I found out last year, that's a completely voluntary,
it is.
so.
But we're all honest people, really.
Everybody's. It's honest. And the mandatory amount is a million that you actually give for.
Right.
That's $17,000.
It's not gonna put a dent in it. No.
It's in a shelf. It's like this red herring number that everybody comes up with.
Well, the federal government came up with it, but yeah, you're absolutely right.
But it has nothing to do with your taxes, is that right?
No. What it has to do with is called your gross taxable estate, and it's basically everything you owned any kind of an interest in during the entirety of your life. And again, unless you're actually in MET territory where you're filing a Maryland estate tax and a pro forma 706 federal tax return, then people just don't care. Frankly, there it is. Sir.
So if you have a will that's 20 years old.
Yes, sir.
Is there any benefit to upgrading that?
And again, it depends on your circumstances and what's happened during the course of your life. A lot of people go ahead and draft wills when they have small children. And by the time they get around to revising their will, their kids are all adults. Now they have grandkids, so on and so forth. So your distribution pattern might change in there. And the other thing is that you don't really need to nominate a guardian for minor children when you don't have minor children. You don't need to go ahead and rely on, your mom for a personal representative when she's probably, not in the best of health and not up to the job anyway. You can go ahead and nominate your children, pick on them.
But from a legal point of view, with changes to the tax laws or whatever.
Well, that really doesn't impact wills all that much, again, unless you have a really honking big estate. Okay, people all over the place.
You have to have one executor, or can you have joint executives?
I tend to recommend one, because the problem with having multiple executors is they normally don't all live in the same place. Every last one of them has to sign every last document, has to be on every last account. And by the time you get done playing round robin for an entire estate's worth of stuff, it can really cause some backlogs and headaches that you didn't anticipate.
Does the executor have to be a Maryland resident?
No, but they have to have what's called a resident agent, which is somebody who lives in Maryland who can accept legal process for them. Yeah.
Most of what you're talking about tonight will only relate to me living in the lottery, but I had a question about the joint account versus having something in your own name or your spouse's name. And how that actually plays out. Right now, my husband and I have several accounts that are separated and a few that are together, including our home. And he's dealing with some cognitive decline to the point where things are going to change. And so our personal representative will be his son, I think, at this point. But I'm just wondering about if you could talk about that would be it. Like what all of our credit cards and things that will have claims against them if they're in both their names or just.
Well, there's a wide array of things that can happen during the course of an estate administration. But realistically, when you're looking at things like joint accounts, what that does is it relieves the burden when the first spouse passes, because everything transfers by operation of law to the survivor. So the surviving spouse has title to everything. Now, when that surviving spouse passes away, Molly barred the door because everything goes back into the probate basket. So at that point, you have to go through the steps and you have to deal with creditors' claims, whatever else will come down the path.
In that same area, we all have bills to pay.
Absolutely.
So date of death, I think our checking accounts stop. Is that correct?
No, and it shouldn't, especially if it's joint, because realistically speaking, what the bank should need is a copy of the death certificate. And that should be sufficient. You as a joint tenant on that account, you still have full right of access.
So you should have, with those husband and wife, you should have a joint account somewhere.
Yes, ma'am.
If you have a funeral and then funeral probably wants to be paid.
That can be tricky, yeah.
What does
Some
the person
people
do?
Well, some people prepay for funeral services. So you can buy an insurance contract that's dedicated to the proposition of burial services. Some people set aside specific accounts with that purpose in mind. And the other part is that after appointment, a personal representative has full access to any assets of the decedent. So if I were to pass away tonight, and I'm not picking on anybody in the front row, when I was in law school, we had taken a probate course. Everybody in the class died repeatedly, and it was grim. It really was. But if I die tonight and my wife passes away soon after me, our personal representative or her personal representative specifically has the ability to go get appointed and then immediately go ahead and start to marshal those assets to collect everything together. Walking around the halls, the long part.
On the topic of personal rep, I'm sitting here thinking, my father died 2 years ago, my mother has. I think that my sister and I are both named as personal reps. Is that common to have more than one personal rep?
It is.
So when my mother passes, together we make an appointment to go to the Register of Wills, and does that mean we have to do everything together? If there's checks to sign, is it two signatures?
Yes. And to be perfectly frank with you, there's a bunch of different ways to handle that. The very first thing that anybody should do is call our office. Because rather than schlep through the metal detectors at the courthouse, all you have to do is pick up a phone and you can ask us questions about particulars. Like who needs to be there, who needs to sign what, can I consent to the service of somebody else? If there's a bond, what do we do about excusing the bond? And there's a lot of different things we can do before the estate ever starts up to make your life easier. We're happy to do it.
Thank you.
Continuing on that, you said if you have two personal representatives, but one's in another state, someone has to, in the state in Maryland.
Yes.
Has to do
serve as a resident agent.
What's involved in that?
And basically, it's a mailbox for service of process.
Oh,
so if the estate ends up in a suit, the out-of-state personal representative has somebody in Maryland who accepts the process of service on that suit. So that's really all there is to that. Additionally, if you have several personal representatives that you would like to go ahead and nominate, people forget that you can do alternatives and contingencies. Like I nominate my son Brad, and if Brad can't serve, then I nominate my daughter Tammy, and if Tammy can't serve, I nominate Ed. You know, if you do it serially, and then it doesn't add up to those problems with going ahead and rotating through the mill. Yes, ma'am.
I have a question regarding with being able to pay bills and things, your representative right after you die. Because of, you have to go through and get the power of attorney and that sort of thing. With everything being electronic now, like my son, I've given him all the papers so he knows what to do. He knows where I have so many bills that get paid automatically. So the bank doesn't know yet that I've died, they'll still get paid. He could go online and pay my bills,
Yes.
use my phone and get the code. Would that be
Yes.
legal? I mean,
Is it legal? Yes, the downside to that is that you run into problems with not having security of your own assets during the course of your life.
well, no, yeah, but he doesn't have access to the things now.
If he doesn't have access,
He
then.
doesn't access, he knows where everything is, but it's in my house in the safe,
Okay.
so that
Okay.
when the time comes, he has that.
Powers of attorney stop at death.
Right.
So even a durable power of attorney, it ceases to function for any real purpose when somebody passes away. At that point, really, if the person isn't a tenant on the account or the
He's the
asset,
executor of the trust, so.
well, he's either gonna be a trustee or an executor. Executor is the personal representative for a will, that's probate. The trustee is for the trust, and that's non-probate.
But he's the, what do you call it? I'm the trustee, I own the trust.
Mhm.
And then there's the
Successor.
secondary trustee. or something
Successor trustee.
that comes
Uh-huh.
in charge when I die.
Sure.
Is that what it is? Yeah, that's what he would be.
And really what he would have to do is go ahead around to all the various places where you have accounts, et cetera, and provide them copies of the death certificate and trust itself. And that way they would be able to recognize him as successor trustee.
Okay.
So that's all immediate and it's by operation of law, and bless you.
Thank you.
Uh-huh.
I have a question as to where I need to go to get certain documents. I was an executor for my mother's estate. And now I'm being asked because my brother from Massachusetts has I guess unclaimed property and he needs her death certificate. Where do I go locally to get her death certificate? She died in Maryland.
Locally, not so much. You can go to the funeral home that did the services for her, or you can go to the Department of Vital Statistics. And they're in Baltimore, but they have an online presence. You may be able to go ahead and order copies online.
Okay, well, I had two funeral homes, one here that prepared her body and one up in Massachusetts where she was buried. So could I go to the one in Maryland or do I have to go to the one in Massachusetts?
Where was the death certificate issued?
It would have been here in Maryland.
Then Maryland is the appropriate venue.
Okay, and I was, as I said, the executor for her estate. And the question is that designation filed anywhere? I mean, I don't have a copy of that anymore, apparently. Is there somewhere I can get that?
If it was a Maryland estate, you can go to the Register of Wills website. It's www.registers.maryland spelled out .gov.
Okay.
And we have an estate search feature. So all you'd have to do is put in the relevant information and it'll bring up the entire record of the estate. And you can buy copies, and they're 50 cents a page, of anything that you might need out.
And so that would reflect that I was the executor of the estate if I needed something.
Yeah, you could print off a copy of the petition to probate, for example, and that shows that you were appointed as personal representative. There would be an administrative probate order that accompanies that.
Okay.
Shows you're the guy.
Probate affect any foreign assets?
Foreign, how foreign? Foreign, different state, foreign, different country.
Different country.
Actually, what governs that is the Hague Convention. And really, you get into some messy territory there. And it depends on whether or not a country is signatory to the Hague Convention. And if they are, then you have to get documents essentially apostilled by the Secretary of State to go ahead and show that you have the authority to act, and then you have to retain counsel wherever else that might occur, and they go through their process. So not easy, and good luck. Okay. Now we're gonna leave off. Good God. Yes, ma'am.
How about when does the estate start paying bills?
When does?
Well, the estate doesn't, the personal representative is the one that's responsible for doing all the bill paying, all the asset collecting, all the distribution and everything else. As soon as the personal representative is appointed.
Or he will have to open a checking account for the estate.
Yeah, normally what happens when we appoint a personal representative is that letters of administration issue. They're a one-page raised seal document that demonstrates that somebody has the authority to act on behalf of an estate. That in a death certificate will unlock any door you want to, with as long as it was solely titled to the decedent. And the personal representative has absolute authority to go ahead and do what's necessary to get from here to there. So collecting bank accounts, changing over to an estate checking account, things like that.
So there would be a checking account for the estate.
There typically is, and on the registrar's website, we have a little link to take you to the IRS that will issue an EIN, which is an employer identification number. And the purpose to that is that when you pass away, your social security number basically gets locked up by the Social Security Administration. And therefore your estate needs its own tax ID number. So you have to get an EIN for the estate. And again, you can do that with letters of administration.
Nothing is easy. Nothing is easy.
Nothing.
And the more accounts I have, the worse it is, I'll tell you.
Yeah.
Well, there are worse problems to have.
I know, but my husband died in March and I had to change everything and our trust was in his social security number, so everything had to be changed to my social security.
Yeah.
And all the medallion signatures you wanted, and it took months.
Yeah, it's a lot. I understand.
I was just reading your question 2 on your thing about how do I open an estate and reading all the things you need. And I'm just thinking about, so I believe that my aunts and my cousins that live in Illinois are gonna be asked me to be their personal representative. So I don't know what, and I'm a lawyer, I don't know what to do, like the moment that they die, like I don't have keys to their houses. I haven't seen them in, some of them in 8 to 10 years. I don't know where their bank accounts are.
Oh, boy.
I don't, I don't know anything. What do you do in that situation? Like, I mean, yes, obviously I need to talk to them about it, but.
The very first thing you do is make really good friends with the people at the Register of Wills office, call them up and say, what do I do? And we have access to a lot of different things that will enable you to go ahead and do things. For example, if you didn't know where any of the accounts were, a personal representative can take letters in the death certificate over to the local IRS office and you get what's called a record transcript. And it'll show you where the 1099s are coming from.
Okay.
So there are little tricks and
ways to do it.
Oh, yeah.
Okay.
Oh, yeah. There's always a way.
Okay, and what do you do if there's someone living in a house that isn't in line to inherit?
A holdover, yeah, landlord tenant is the exclusive jurisdiction of the district court. So a personal representative has authority to go ahead and file suit on behalf of the estate, but it has to be done through the district court.
That's gonna be fun, cool, thanks.
Sense of adventure, that's necessary. Okay. So really, what you can see here is there's a lot of different ways to skin a cat, and none of them are anything to be afraid of. And the thing that I would impress on you is that the Register of Wills website is an amazing resource. There's more than you ever wanted to know. I've probably given you what you wanted to know, but everything you ever wanted to know about probate in Maryland, there's going to be recourse to it there. And the nice part is our office people are pretty friendly.
Where's your office?
Where is our office? One of the courthouse.
No, I mean for
The website.
website.
It may be on there. I'm not entirely certain. I haven't looked at that in a long time.
No, here it is.
Oh, on the front page.
sneaky.
Okay.
The question, you said that probate doesn't cover IRAs and retirement accounts,
Beneficiary driven accounts.
beneficiary driven accounts. So none of these things you've talked about deal with that, and they don't go through probate or what?
With exceptions, like there's an exception to every rule. If there are no beneficiaries listed on a beneficiary driven asset, then the default is payment to the estate. So if you had an IRA and you didn't pick out your beneficiaries, that would default to your estate. So I mean, there are rules and there are guidelines for just about every form of asset.
How would that apply to a pension?
Pensions typically are in the form of defined benefit, and normally what happens is that you can have a single life or a dual life annuity. Normally what that means is if you have a beneficiary for your pension, that goes outside the probate process, your beneficiary will just start receiving whatever amounts the pension dictates. But there's no probate issue with that.
Is it terrible to die intestate if you want your money to go the way that the intestate?
I'd say it's terrible to die no matter what.
Well. Yes.
You know, all funnies aside, what you lose is you lose the ability to determine who your personal representative should be. Because the court's gonna pick that out, or the registrar is gonna pick that out. You lose the ability to go ahead and do anything other than the loss of intestacy for terms of distribution. You lose the ability to excuse bond in the state. And there are two forms of bond. One is nominal, the other is full. Nominal means in name only. So when everybody excuses bond under every other circumstances, Maryland's not so forgetting. So they require a small bond. The penalty sum on that is normally about $25,000. Full bond means that you have to go ahead and file a private bond for the entire amount of the estate. So sometimes you can end up in sticky situations where you just didn't anticipate it harder. So yeah, better to have a will.
So the cost, then they appoint somebody, so that person is gonna cost you to settle the estate, right?
Depends.
No.
Do they have a right to a commission? Yes. Is there a statutory commission structure? Yes. Do they have to get court approval to get it? Yes. So sometimes family members do it just because, sometimes family members do it with an eye toward the commission.
So though the state can appoint a representative, you can ask that one of the family members be that person that's appointed.
That is the whole point to a will, is you get to determine who your personal
But if you
representative
haven't
is.
got a will,
If you haven't got a will, you don't have a choice.
you don't have a choice. It'll be somebody the state.
It'll be somebody that either fits into one of the classes and categories of 5104 of the Estates and Trusts Code, which is the loss of intestacy that we were talking about.
Okay.
Or it's going to be somebody that the court appoints.
Okay.
So I mean, there are limited options that way.
Okay. Thank you.
What is the amount that a personal rep can charge?
9% of the first $20,000, 3.8% of the balance above $20,000. And not to put too fine a point on it, but that approximates about 4% of the gross estate.
Steve.
You used two abbreviations earlier, TOD and POD. Is there a difference between the two?
TOD simply means transfer on death. POD means payable on death. And they're basically the same form of beneficiary driven transaction where it's your asset until the day you pass away. Then it transfers over to that beneficiary. Yes, sir.
It's important to have will, trust fund, or payable PODs on most of your assets.
I'm normally just happy with a hot meal. There are benefits and drawbacks to each and every one of those things. If you're gonna have a trust, you might as well have a pour over will. So when you retain an estate planning attorney to do that for you, they'll ask you if you want to do both, and the answer is yeah. If you just have a will, just the will itself will do the trick. If you want to go ahead and add family members on as joint tenants with you for any type of asset, you can certainly do so, but the risk that you bump into is that they would have a right of immediate withdrawal for assets. So that can create problems occasionally. Most people want to feel a little bit more secure about their assets while they're alive. That's where the TOD and POD beneficiary designations come in. And outside of that, if you really don't mind much one way or the other, you can allow it to go through probate. That's perfectly okay. The downside to probating an asset is that if you have creditors, significant creditors, they will go ahead and attach claims to the estate. If you don't have any creditors, no worries. How are we doing? Yes, sir.
What's the time frame for creditors?
6 months post-appointment.
6 months from when?
Post-appointment. From the appointment of a personal representative, then 6 months.
And then 6 months, not from date of death. And not from publishing in the newspaper.
Yes and yes, but really the creditor's claims period allows the estate to stay open for that 6 month period. And that claims period can't close before the 6 months post-appointment. Now, claims can be untimely as a result of being too close to date of death, or far enough away from date of death. So if you have a decedent who died on January 1st and a claimant comes in after the personal representative is appointed on July 1st and then files a claim on December 1st, they're untimely, because you have to file a claim within the shorter of a period of time of 6 months post-appointment or 2 months post-appointment if the personal representative serves a copy of the notice of appointment on the creditor, or 6 months after date of death. So there's a wide array of different things that can happen.
Sorry, I have a million questions. So, for example, say my mother-in-law passes away, and she's renting an apartment. If the estate doesn't close for the estate doesn't close for 6 months, what happens to her stuff? Like, we don't want to keep renting a gajillion-dollar apartment. What do you do?
I don't know, I'll probably move into the gajillion-dollar apartment.
Have you seen what the apartments in this neighborhood cost? It seems like $1 jillion to me.
When you get letters of administration as the personal representative, that enables you to go ahead and do things like talk to the landlord and figure out what you need to do to go ahead and conclude the contract there. You can actually move the property to someplace where you can store it if there's any value to it. What a lot of people are finding now is that household furnishings aren't worth what they used to be. And it's easier sometimes just to let them go. You give them to Goodwill or what have you, Purple Heart Foundation. But I mean, like I said previously, if you're the personal representative, you have the ability to act on behalf of the estate, up to and including going and telling the landlord I want access to the apartment. Yes, ma'am.
If there is a trust as opposed to a will, do you still need a resident agent in Maryland? And is it necessary for your executors or whatever they be called for a trust to physically come and sign lots of documents in Frederick? And if there is, for how long a period does that go on?
No, and no. Trust essentially is a private document. The difference between trust and probate is that probate is a legal process that's public, and trust is a private document that is not. So if you have everything squared away inside a trust and you have a successor trustee all picked out, basically they can, with a copy of your death certificate, go around and transfer assets as necessary to go ahead and maintain the trust and then make distribution. Now you're getting tired, I can tell.
Overwhelmed.
Yeah, there's a lot of information. There's a lot of information, and the most important thing I want you to take away from this evening is that if you call our office, all this information is accessible. We're here to help. We value the ability to serve, and we want to make sure that everybody understands that we're here for Frederick County families. Okay,
One quick question, how different is it in the different counties in Maryland?
pretty widely. You go to places like Garrett County and they're kind of smaller. You go to the Eastern Shore and sometimes the registrar's office has 2 or 3 people.
Okay, well, like in Columbia, Maryland, I don't know what county. we're in.
Howard County?
Howard County, so is there comparable to here, or is it big, I'm sorry, bigger, because it's.
Pretty much. No, it's about the same thing. As a matter of fact, I think they're a little smaller than our office.
Oh.
What is your phone number?
301 600 6565. And again, my name is Chris.
We get it called.
Oh, yeah.
Do you have enough people to answer the phone?
Well, we have a dedicated receptionist. Her name is Leah. She's nice. Be nice to her. She will go ahead and make sure that everything goes smoothly as possible. Okay. How are we on time?
Very good, yes. All right. Anyone else? Thank you very much, appreciate it.
Thank you.